Joining me now is Kenji Yoshino, professor of constitutional law at NYU School of Law, and Melissa Murray, also a professor of law at New York University, MSNBC legal analyst, and former law clerk to Justice Sonia Sotomayor. Thank you both for being here. This is like a dream panel for this, but I do have to go to you first, Melissa, because I'm sorry, but I don't speak Supreme Courtese. But all I read was shade, and more shade from your former boss, Justice Sotomayor, and her colleagues. They opened in their, what felt like more of a dissent, honestly, than a concurrence, in which they said, y'all did too much. You just had to say states can't enforce Section 3 and leave it there, but you had to keep going. You felt like you had to tell people how to enforce Section 3. You felt like you had to instruct Congress. Did you read that as shade as I did?
I think it was shade all the way down, Joy. And more than that, I think this was nominally a concurrence, but it had real big D energy, big dissent energy. And they basically made clear that this is a court that's kind of high on its own supply. It name-checked the Chief Justice in the first opening paragraph. Again, I think that was meant to indicate that he was the principal architect of the per curiam opinion, and also to make clear that someone who is ostensibly an institutionalist at this court didn't necessarily seem to be an institutionalist in this instance, where the court went much further than they needed to decide this question. And by the end, these three ladies were essentially saying that this court is pretty much enabling Donald Trump in a lot of ways, not necessarily directly, but in these opinions and going further than they have to, they've basically laid a foundation where Section 3 is virtually inoperative after the election, and Congress is authorized to do everything. But Congress, as Jenna Griswold said, is not really in a position to act expeditiously going forward.
It's a non-functional entity. You know, to say let them fix it is like saying don't fix it. Kenji Yoshino, welcome to the show. It's so great to get a chance to talk with you. Let me read a little bit from because it seemed to me that at the end, and it definitely felt to me like a John Roberts opinion. Now, I've read a few of these. I'm not a lawyer, but I've read enough of them that I'm like, I recognized his voice a little bit. He writes, or somebody, one of them writes, because it's not signed, all 9 members of the court agree with this overall result. Our colleagues writing separately further agree with many of the reasons that the opinion provides for reaching it. And then they talk about blah, blah, blah. So far as we can tell, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. These are not the only reasons the states lack power to enforce that particular constitutional provision with respect to federal offices, but they are important ones, as is a combination. Like, this is like kind of condescending. Not, they're saying these are important things, but not the important things that some of our colleagues would have it. Just one particular rationale. It seemed like there was a little bit of Snydery at the end of his decision in saying these people are dissenting, but they really don't dissent. Do you read it as a lot of people, a guy named Mark Joseph Stern actually went and double-clicked on it and looked at the metadata? And it seemed that the way that the decision was originally put out, it was put out like a dissent, but that they put it out as a concurrence. What do you think of the intrigue about whether this was truly a concurrence or a dissent? Oh, he can't. I can't hear you. You're on mute. You're on mute, Kenji.
Sorry.
There you go.
So I 100% agree. I was about to raise Mark Joseph Stern's kind of magisterial sleuthing here, where still, if you copy paste an opinion, try this. Sotomayor, Brown, and Kagan, JJ, and you copy and paste it into another document, it will show up as Sotomayor J dissenting in part and concurring in part. So this is just kind of extraordinary. An extraordinary window into the fact that this was probably originally written as a dissent. I find it very hard to look at that jab through Dobbs of saying, you told us to be minimalist, Chief Justice Roberts, to the majority per curiam opinion as anything other than, look, this was Chief Justice Roberts who wrote the opinion. I will add to that, under this kind of very thin veneer of unanimity, there are so many tensions and dissensions roiling underneath that surface. I will add to that only Amy Coney Barrett tone policing the dissent, because she says, I would not amplify this disagreement with stridency. So essentially she's saying, I agree with you on substance, I just disagree with the tone of these three dissenters. So it's pretty kind of fierce right over there with regard to the level of tension under the very, very, again, thin veneer of unanimity.
Absolutely. And I'm sorry, but the three dissenters, my three amigas, as I'm calling them, they give me life. I'm sorry. They give me life everlasting. Every time they write something, it's like boom, shakalak. I love it. This is another thing. Let me read. This is from the ruling. It says the case raises the question of whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. Okay, so if that is the case, let me come to you, Kenji, first, Yoshino first. In Article 2, Section 1, Clause 5 of the Constitution, now I'm playing play lawyer on TV, it says no person shall, except for a natural-born citizen or citizens of the United States at the time of the adoption of the Constitution, shall be eligible to the office of president, nor shall any person be eligible who shall not have attained the age of 35 years and been 14 years a resident within the United States. So if states can't enforce Section 3 of Article 14, can they enforce that? Couldn't a 12-year-old say, I'm running for president, or Arnold Schwarzenegger? Could a state knock them off the ballot? Because that's a federal office. They'd be running for president. If the states can't enforce it, can they enforce this?
Yeah, absolutely. This is if I want Taylor Swift or Prince Harry to be president, these are two figures that I know are near and dear to my colleague, Professor Murray's heart, then, why shouldn't I be able to vote for them as well? So Chief Justice Roberts is an answer to that, and saying that the 14th Amendment was part of the Reconstruction Revolution that gave a lot more power to the federal government. But whether or not that's a sufficient answer, I think, is a really important question for us to be asking. And there's certainly a stark textual contrast in between the obviously self-executing provisions, like you need to be 35 years old or you need to be a natural-born citizen on the one hand, and you can't have engaged, by the way, in an insurrection as an oath breaker, right, on the other.
And then, Melissa, where do you think this leaves? I mean, there doesn't need to be enabling legislation for you to not be able to be 35 and be president. So if this is not self-executing, how could Congress keep an oath breaker out of office? Like, what would that law have to say?
Well, that's the million-dollar question, Joy. I would also back up a little bit to say you need to read this decision in light of the court's other decisions on the Reconstruction Amendments. And this is a court that for years has been hell-bent on limiting Congress's authority to enforce the provisions of the 14th Amendment and the other Reconstruction Amendments. Think about Shelby County versus Holder, for example. It is never, ever tried to give broad grants of power to Congress to enforce civil rights. And instead, it has always prioritized the prerogatives of states under these circumstances. So here's the very unusual circumstance where we see the court inexplicably prioritizing the states and apparently arrogating some power to Congress. That never happens in this court, and certainly not with respect to the Reconstruction Amendments. And I think it belies the fact that although this gestures toward expanding the authority of Congress to enforce Section 3 of the 14th Amendment, the real group that has been given power here is the court to decide what the scope and substance of the Reconstruction Amendments mean. And they've essentially arrogated power to themselves. And this is an ongoing theme with this court. This is a 6-3 conservative supermajority that is constantly trying to limit the authority of Congress and to take that power for itself.
Absolutely. I mean, it says very clearly, pending court review, they should do a law. It is wild. And last question to you, Kenji Yoshino. They go on about this patchwork that would likely result if you allowed a state like Colorado to make this decision. But to your point, only the three dissenters, or if you want to call it concurrent dissenters, have been consistent in saying the federal government should be able to enforce the right to vote and access to the ballot. The other six are really not on that page, and they don't seem to mind, the other six, the patchwork when it comes to disenfranchising laws that make it harder to vote in Georgia than it is to vote in Colorado. Then they think the patchwork is fine. Doesn't that seem a bit inconsistent?
Yeah, it's very strange. I mean, I just want to bolster what Professor Murray just said right now, which is this is not a conservative majority that seemed to be expansionist with regard to federal power, or as you say, a court that has been, concerned, right, about this patchwork. So we can think about the Bernie case, or we can think about the Moore versus Harper case, right, as case studies of each of those. So this is really inconsistent, and it leads to the conclusion that, as Sotomayor said during the oral arguments, this is gerrymandered around one person. This is a rule for one person, and that person is President Trump.
There you go. Kenji Yoshino, Melissa Murray, thank you both very much.
If it makes you feel any better, I have already put evac on alert. He's ready to go if it comes to that. General, I can assure you.
Hey, General, let me into the war room to see you, so I had to hack my way onto this frequency.
This better be critical, Willie.
Sir, come on, when is it not, please? Okay, couple of things. I'm running low on the dough. I was thinking about taking a couple of months sick leave, maybe starting today. And, oh yeah, I intercepted a transmission from Megatron.
Then send it through.
Yes, sir, right away, sir. And so I was so dang good on the other stuff.
This is your last warning, insects. Relinquish what remains of the Allspark.
So who's the insect? You? What?
The
Who's the
Autobots
insect?
cannot protect you. They were defeated on our
way.
world, and we will defeat them here.
The Megatron.
This was just a diversion. Security, please bring up. Rabbit, she's already inside. Deeds! Give me an update on that reserve. Boss readiness. What was his name? What was it?
Evac, sir.
Right, evac.
She's right in front.
We're facing a heavy sustained attack. They appear to be after the Allspark. General! General! We need to evac immediately. Evac everything. Hold on. National security advisor. Stay down. Check it out. Failed their mission operations. The amateurs for a suicide mission.